Thank you, counsel.
Thank you.
Ms. Sherman?
I'm sorry.
Oh, I'm sorry. Well, okay. Do you have any further?
Do you have a question?
Yes.
Yeah, I'm sorry. Why don't you get back there? I was jumping the gun.
And I'm glad that the chief will exercise his traditional equitable authority to allow you to ask this important question.
Justice Thomas? Anything further? Justice Alito? Justice Sotomayor?
Isn't fraud an equitable ground for tolling?
It can be, yes, absolutely.
Yes. And for causes can also be equitable ground for tolling?
What was the word, causes?
Causes.
Oh, sure, yeah.
Okay. So why did Congress bother writing those exceptions into the statute?
They wrote those into other portions of the statute.
13, 14,
Oh, the prod, yes.
46.
I'm sorry, yes, in
The
1446C.
diversity one is under 1446C, but even why bother writing a separate one?
Well, sometimes what Congress will do is it'll have a belt and suspenders approach where even if equitable principles apply, they want to make sure that they will be applied in specific circumstances.
So
and there
you're
was
saying
a circuit
these
split.
are just redundancies.
Well, there was a
What
circuit
do
split.
I do with the fact that 1455, just two provisions after the last, or one provision after 1554 on the intellectual property claims, Congress actually used the words equitable tolling and said in the criminal context, you apply equitable tolling. So it knew how to use those terms. Why didn't it use it here?
Right. So in the criminal context where they said that you could, for good cause, excuse the deadline, I have 2 points on that. First, generally, it's harder to remove a criminal case from state court to federal court. And so Congress may have wanted a more capacious statutory standard to make clear that federal courts had that authority. But the main point I want to make—
That makes no sense to me. If it's capacious, why not just leave it alone in 1446? Why not apply it there?
Well, the main point that I want to make is that when Congress adopted the good cause standard for criminal things and didn't do it for the rest of it, there are 2 inferences you could draw from that. One would be Congress didn't want equity. The other one would be that Congress assumed that equitable exceptions applied, and it didn't need to amend 1446 to do the same thing that it was doing in 1455. And when you have competing inferences—
But it needed to add fraud as an exception to removal within 30 days, and needed to add it with respect to intellectual property?
Yeah, so just let me finish my answer and then walk through each one of those. So when you have these competing inferences, what did Congress mean? Did it intend to exclude equity or intend to include equity? Competing inferences are not the clearest command to cut off courts' traditional equitable
No, but I
authority.
find
so that's there. So with respect to intellectual property, Congress was setting aside a separate area of subject matter jurisdiction and giving it separate rules. I mean, that's why in all of these elsewhere things, we're talking about pure structure now, not text, Congress cross-references 1446B to make it clear that it doesn't apply, that you've got literally different sets of rules depending on subject matter and party. So as for the fraud exception, there was a split among the lower federal courts about whether fraud was an equitable reason that courts could grant tolling. And so Congress resolved that split. And what it did is it made the fraud exception, and then on top of that, it made the 1-year limit. But none of that provides the clearest command that Congress intended to handcuff, again, restrain federal courts from exercising their traditional equitable authority in all other cases. That was simply solving a lower court problem, Justice Sotomayor.
Thank you.